Good morning, everyone, and welcome to this international conference on religious diversity and neutrality in public education and the public sphere. This is a hybrid conference for participants. All speakers are in the room, save one. We'll give some details on that later, but it's hybrid for participants at home. So thank you also for joining us online. I'll be brief now. My only job right now is to introduce the rector of our university, who has generously welcomed the invitation to present a few words to open this conference. So, and we'll give some details as organizers afterwards. So I'd like to welcome Rector Bernard Vanheusden to the stage.
All right, dear guests, dear colleagues, ladies and gentlemen, thank you very much. Also to the people, I think you have to look up now, to the people online joining us from all over the world. It's indeed my great pleasure to welcome you here at Hasselt University and to the very heart of our city campus. We have two campuses, a green campus 5 kilometers away from here in Diepenbeek, and then this city campus in Hasselt, the city of Hasselt. I'm particularly proud that I can open this conference because I'm a lawyer as well myself. And I think we have many lawyers here present today, also non-lawyers, other disciplines, but definitely a lot of lawyers. There's a strong irony in this place, actually, and in the history of this place. Initially, this former prison, and you may have seen it already when you entered the building and walked around a little bit. But initially, this was built to wall off its occupants from the outside world. Doors locked, windows barred. Today, it's an open place, letting society in and serving as the proud home of the university. In a way, this building symbolizes how universities over time evolved from almost isolated places where knowledge was stashed away into places deeply connected to society, with ideas and people flowing freely. And there's another irony here. Apart from a public place of assembly, information, and debate, this former prison is also, of course, a place of education. And not just any education, the education of law students, no less. Ladies and gentlemen, we are very proud as Hasselt University to co-host this conference together with the Inter-University Center for Educational Law and Policy, a collaboration spanning different research units and domains, constitutional law and educational law. As we all know, the relationship between state neutrality and religious diversity gives rise to fierce political and legal debates, battles and controversies across Europe and beyond. During this conference, you will tackle and debate some urgent questions and issues. How do or should European states respond to religious diversity in the public sphere and public education? And what does it mean for European states to be neutral in the first place? Not only are we honored to host you here today, but we're also very proud with the list of speakers and panelists. I think if I've had a look at the program, it's clear that this conference brings together scholars and experts from around Europe who will reflect on the multifaceted nature of the relationship between state neutrality and religious diversity, and who will provide perspectives from at least 3 disciplines, being law, political theory, and sociology. Today, you'll hear from leading academics from across Europe, from a former judge and vice president of the European Court of Human Rights, from a colleague rector of a Dutch university, from a member of the Dutch Council of State, and from many, many more colleagues and friends of this university. I think we can all agree that it is an impressive list of speakers and panelists. However, I would like to mention that this conference also gives a voice to less established yet promising junior researchers. They will present their doctoral research on freedom of religion and education law in Europe through a poster session. So I urge, of course, all of you to have a look during coffee breaks and lunch break or right after the conference. So definitely have a look. I'll guess that Stijn will indicate exactly where you can find the posters. Before I give the floor to my colleagues, I especially want to acknowledge Professor Jan de Groof from the College of Europe and Professor Kurt Willems from KU Leuven. In the past few months, it's clear, and I have organized conferences in the past, I know how much work it takes. And it's clear that if you can closely collaborate with colleagues, that you can make this conference a success. Hasselt owes you, both of you, a lot of gratitude. A personal thanks also goes to our governor of the province of Limburg, Jos Landmeters, who financially supported this conference. So that's, of course, greatly appreciated by the university. And of course, last but not least, I would like to thank all the colleagues involved from Hasselt University, and then specifically from the Center for Government and Law, and then more specifically, the Constitutional Law Unit, with I think mainly Stijn Smet as prime organizer for co-hosting this event together with the Inter-University Center. Ladies and gentlemen, dear colleagues, I wish you a very fruitful conference. I will be staying also for the first keynote, so I very much look forward to that. Have a look, take some time during the coffee break to have a look around in this beautiful old Bristol. You will also see some the old cells, which are now used by students as study cells. So it's a very interesting, a very nice touristic extra asset for the city as well over time. So we're very proud of it. And I hope you have a very pleasant stay at Hasselt and hope to see you soon again. Thank you very much.
Thank you very much, Rector, for these kind and generous words of introduction. Also, on behalf of the Faculty of Law of Hasselt University, I also extend a warm welcome to everyone online and here to this conference on the relationship between state neutrality and religious diversity, an important and extremely challenging theme in Europe at both the supranational and the national level. As you've heard from our rector, we're extremely happy to have gathered an excellent range of speakers to discuss these themes with us today at this conference that is generously supported by a number of sponsors, including Hasselt University, the Research Foundation Flanders, the Faculty of Law of Hasselt University, the Governor of Limburg, as has been mentioned, and the Inter-University Center for Education Law. We thank each of these institutions, persons, and bodies, as we could not have brought together this group of scholars here today without their support. I will now hand over briefly, if it's all right, to my co-organizer and colleague, Professor Jan de Groof, for a few additional words before I will return with some necessary, essential practical information on running a hybrid conference.
Yeah, thank you so much, Stijn. Yeah. So, Mr. Rector, thank you for being here. Thank you for your loyalty, your commitment to this and to so many other research programs in the sphere of public law, international law, human rights law. Explicitly, also, I have to add that I'm quite emotional to sit down again in this aula, named after the first rector of this university. Louis Verhagennaam was quite familiar. He's one of the, well, it was the founding father of this university, young university. And how young universities can be that innovative. We have 7 universities throughout Belgium. Most of them are rather old-fashioned, a little bit conservative, or very conservative indeed. And this university, young, innovative university, made a difference. And we have to to pay honor to the founding fathers and to the new concepts of education and research at this university. Special thanks also to Rector Magnificus and Chair of the University of Tilburg, Wim van der Donk. Happy that you made it to be here. Highly appreciated. Well, church and state, religion and the law, they are definitely favorite domains of reflection for those who study and practice constitutional law, administrative law, human rights law, education law, governance, besides, of course, the social sciences. It's a long-standing tradition of the European Education Law and Policy Association and ICOR, the Flemish Institute, long-standing tradition to deal with the topics of religion and belief in the public domain. The last 25 years, yes, we do exist, the association do exist already practically 30 years. We organized 7 or 8 conferences spread over those decades. The first one was inspired by the quite impressive documents originated by the Scientific Council for Government Policy of Netherlands, believing in the public domain. Not by hazard, the council by that time was headed by Rector Magnificus and President of the Tilburg University, colleague Professor Wim van der Donk. Fascinating document. You should have a look at it again. And many other ELA meetings and ICOR meetings on Islam and on religious instruction in public schools. Julianne Cocotte, Advocate General, Court of Justice, was very loyal participant on those ELAs. Unfortunately, she could not make it to be here, but she promised me in a phone call that she will appreciate to still be involved in research projects coming out as spin-off of this quite important, very important meeting indeed. And on the world meetings on human dignity and education and religion in Rome and in Bruges. So it is a fascinating, an intriguing, a complex and a fundamental issue. Why? How the state is dealing with worldviews, with religion, with philosophy, philosophical and ideological beliefs, goes to the very heart of the identity, cultural identity of a nation. At the same time, it belongs to the core, to the inner circle of fundamental rights. Some philosophers of law, George Jelinek, mentioned that religious freedom is probably the most, the mother, he named it that way, the mother fundamental right for all others. And of course, religion and belief, Weltanschauung, reflects the past. And it is determining the future. Future starts yesterday. May I quote one of my definitely favorite constitutional court worldwide, is the South African Constitutional Court. Repeatedly, that court mentioned religion as a vital part of the social fabric. My students have to read frequently those court decisions, those judgments of the Constitutional Court on religion. They are making the difference indeed. On the same time, we discussed, debated, many of us, on the classifications of church-state. Now, there are five typologies, as you know. The state suppressing religion, atheists on the other side, theocracy, and official religion, state with official religion, and at the middle, at the center, the secular state. Secular, separate from religion, but interacting with and to some extent supporting religion or religions. There are various systems of secular state, as we will know this afternoon and this morning again. It is kind of a cooperative model, the cooperative model. And that could be European feature of church state those days. Will it be the same for the future? That should be debated today. Confessional schools, non-confessional schools, and secular models. Well, European model with the three features: human right on religious freedom, collectively, individually, in public and in private. Second, autonomy of the religious organizations. And three, the distinction between religion and politics does not exclude cooperation. There are so many fields of cooperation between state and church. There is quite excessive research on those issues. But even in France, l'État le plus laïque au monde, the most outspoken secular state. There are several domains of cooperation. Chaplains have access to schools. Timetables do facilitate religious instruction. And in all evidence also the contract between the state and Catholic schools. So there are many shades of secularism and neutrality, many ways for the state to support religious beliefs. In hospitals, in the prisons, in the army, media, and of course, schools. We will debate definitely on the large appreciation, margin of appreciation laid down by the European Court. It seems to be based on two elements: large margin of appreciation. First, lack of European consensus on how state will deal with religion. And secondly, the church-state relation reflects societal choices by excellence embedded in law and in politics. Question will be raised: what about European coherency? What about this European dimension, the common, remember, common European values, common European educational space? And secondly, the secularism is under debate from within the court. François Turckens could not make it to be at a very final stage, could not make it to be here, but reread her dissenting opinions. Quite interesting on that scarf, Sahin case, where she is quoting a certain paternalism within the judgment, a negative signification of the headscarf. Is that in line with the non-neutral approach of the court? And yeah, we will touch on other cases also. Is there kind of a doctrinal secularism in the head of judges of the European Court of Human Rights? A non-neutral doctrinal secularism, as mentioned by some researchers last years. So it's under debate in France for several reasons: multiculturality, and of course also moral relativism. There is even one notion which is worse, namely moral indifferentism. I guess from European perspective, we have to take care that will not be the overloading. Yeah, and then finally, in several countries, we have the debate on integrating the concept of secularism in the constitution, like in Belgium. The ban of religion from Respublika, outside Respublika. Is that a sign that belief and religion does not count in public domain? So many issues, their colleague and friend Stijn will be raised this morning, this afternoon. Let us go perhaps quickly to the first keynote.
Thank you, colleague de Groof. As is wont to happen at these conferences, we're about as much behind as we have used already, but we will catch up at some point during the day. Now, before we kick off the program in earnest, I do have to give some practical information, especially since this is a hybrid conference. For online participants, you will have noticed that your camera and microphone are standard disabled. They will remain so for most of the conference, but we do encourage you to join the conversation online through the chat. So we have somebody moderating the chat. They will put your questions and comments to the speakers when the time arrives. You will also notice that whenever a PowerPoint presentation is being used, you can actually toggle between both screens. So I hope you figure out how to either see the speaker or the PowerPoint. Also some practical information for participants in the room. All coffee breaks and lunch as well will be served in the room where you were for registration, and signs will continue to lead the way throughout the day. As part of the program, as you heard from our rector, indeed, we have the honor of having a number of PhD students present their doctoral research in the area that we are discussing today throughout the conference day. Their posters are on display in the break room as well. Please chat to them. They will be present next to their poster at some point during the day, actually during the lunch break. We do want them to be able to enjoy the conference as well and not be glued to their poster, but know that you will have the opportunity to talk with them over the lunch break. A final note indeed concerns some last-minute unfortunate changes to the program. As you will have heard, regrettably, Advocate General Cockott and Professor Tulkens were forced to withdraw for very understandable reasons. Some of our speakers, I'm very grateful to them, have come to the rescue at the last minute, filling in and stepping up as either discussant or panelists, and I'm very grateful for them having done so. Professor Nussberger has the misfortune of being felled by COVID-19 at the moment and is quarantined at home, but I have noticed that she has joined us online, and so she will be able to deliver part of her address online as well. Without any further ado, I want to move on to our keynote speaker, Professor Sir Malcolm Evans. Let me first introduce you briefly before I invite you to the stage. So Sir Malcolm Evans is a professor of public international law at the University of Bristol, where he also served as a number of functions, including that of Dean of the Faculty of Social Sciences and Law. His research interests are quite wide-ranging. They range from the law of the sea all the way to international protection of human rights, with a particular focus in the latter area on religious freedom and the prevention of torture. He has served for over a decade, I believe, as a member and chair of the United Nations Subcommittee for the Prevention of Torture. He's also a member of the OSCE's advisory panel on freedom of religion and belief. And final element, I could go on all day probably, is that he's one of the editors of the Oxford Journal of Law and Religion, one of the leading journals on law and religion, and the author and editor of numerous leading publications in the field. We're honored to have you here with us today to deliver the keynote address to this conference on the theme of state neutrality and religion in Europe. What's the prospects? I would invite you to join me at the stage.
Well, thank you very much indeed for the welcome, and particularly for being here and for staying with the vision of being able to bring us all together for a conference of this nature. If I can say, speaking for myself, this is the first time I have been able to leave the United Kingdom in 2 years, and for someone for whom previously being in the country for 2 weeks was something of a novelty, the idea of once again being able to come and visit friends and participate in events of this nature anywhere is remarkable. And I know, for having spoken to people, that so many in this room are saying the same thing. So a huge thank you to the organizers for having the vision and the commitment, and also the foresight for working out how long it would take before we would be able to get together like this again. Remarkable at all levels. The other thing I would say, I hadn't realized until I got here that this was formerly a prison. And so, as Stijn said in the introduction, having spent 10 years leading a UN committee on torture, it's an inspiration to know what can be done with prison estate and how it can be converted and turned into other uses. So this has already been an inspiration in those two regards before we even start. Enough with inspiration, we can now be uninspired, as I spend a little time delivering an introductory paper to you on the theme of state neutrality and religious diversity. And I need to say at the outset that I really do need to be careful in how I say what I want to say this morning, since I'm conscious that if I'm not careful, this could very easily become an off-key address rather than a keynote address. I really don't intend it to be that way, but I do think that we are living in a slightly different era now than the one we lived in before, for a number of different reasons, and I will not go into what they are now. And it is an era, I think, that calls us sometimes to perhaps challenge some of the orthodoxies around what we have thought, and more importantly, how we present what we think. And in a way, the idea that I'm trying to get over in the paper today is to try to think again about how we engage with the idea of neutrality in relation to debates and discussions concerning freedom of religion and belief, and how that plays out in practice. Now, the concept paper setting out the aims of our meeting explained that its central objective is, and I quote, to analyse the requirements of state neutrality in the public sphere and public education from a multidisciplinary and comparative perspective, as we have heard, so as to identify varying responses to religious diversity across Europe. And there are two specific questions. What does it mean exactly, I love the exactly, for European states to be neutral? And secondly, how do or should neutral states respond to religious diversity in the public sphere and education? Now, as any good academic knows, that if you don't know quite what to say or where to start with something, the thing to do is to start dissecting the questions that you've been asked to address and say why that is not the relevant question to address. I'm not going to do that because, fortunately, these are very difficult questions, but others have been asked to wrestle with them. For me, the organisers have asked me to do something slightly different, address a slightly broader and overarching topic, this being state neutrality and religion in Europe. What's the prospect? What's the prospect? Now, being asked this question made me very happy, since the title poses a question which I believe can be answered swiftly, easily, and confidently. In my view, the answer to the question is none. There is no prospect of state neutrality in relation to religion in Europe. Indeed, I don't think there is any prospect of state neutrality in relation to religion anywhere else for that matter. And more importantly, why should there be? And even more importantly again, how can there be? I'm not a political, constitutional, or legal theorist. I'm not quite sure even what I am. But I have worked extensively for many years at the interface of law and policy on matters concerning, among other things, freedom of religion and belief, both nationally and internationally. And when reflecting on that experience, it struck me that one thing I have never really encountered is a conscious desire by those involved in policy making to be neutral in relation to religion in the singular, by which I mean neutral to the very idea of religion. The fact of engaging in debates concerning the relationship between church and state, or possibly between religion and the state, the very fact of engaging in this debate assumes the legitimacy of the underlying concept of church and state. After all, you do not enter into a serious discussion of the nature of a relationship or govern through law a relationship with someone or something, the very existence of which you deny. You may disagree with it, you may disapprove of it. You may even deny the reality of religion in the sense of asserting that religion is not real, that it's all nonsense, make-believe, the opium of the people, and so on and so forth. But what one cannot deny if one defines a position or crafts a relationship between the state and religion, is that religion has been acknowledged by the state as a phenomenon which is present, is important, and is important enough, and is real enough for the political community to engage with it. And even in that very thinnest of sense, this is not, I would argue, a position of neutrality. Understood in that sense, there is not the slightest prospect, in my view, of Europe or anywhere else being neutral in this thinnest of senses to the concept of religion. And for the avoidance of doubt, human rights law, of course, sort of precludes this anyway. Irrespective of its meaning and content, think about it. Surely, the very fact that the European Convention on Human Rights, and indeed the rest of international human rights law, requires that states respect the freedom of religion or belief as a human right, means that states really cannot, or at least ought not to be, in inverted commas, neutral about religion. Just as the ECHR is not neutral in relation to other rights which it sets out, or is not neutral in relation to the foundational assumptions of the political project on which it is founded, nor does it pretend or purport to be so. States do then have an obligation to uphold or to respect the freedom of religion or belief as a matter of human rights law. Not only can states then not be neutral in relation to religion, human rights law seems to require them in that sense not to be neutral. They are enjoined to be, in the very loosest of sense, pro-freedom of religion or belief. Now, of course, this absolutely does not mean they must be for religion at the expense of other rights, or more pro-freedom of religion and belief than any other right within the human rights canon. But it does sort of mean, at least it means to me, that they cannot be against religion or belief as a concept as such. No, state neutrality in relation to freedom of religion or belief, I don't think is genuinely an option. Indeed, as we all know, and I quote, "Freedom of thought, conscience, and religion is one of the foundations of a democratic society within the meaning of the Convention. It is, in its religious dimension, one of the most vital elements that go to make up the identity of believers and their conception of life, but it is a precious asset for atheists, agnostics, skeptics, and the unconcerned. The pluralism indissociable with a democratic society, which has been dearly won over centuries, depends on it." I do wish I'd written that. But everybody in this room will know, without me telling them, that that is paragraph 31 from the Kokkinakis case, Kokkinakis v. Greece, the first decision of the European Court of Human Rights relating to freedom of religion and belief. The first. It didn't have to think too much or develop much of a jurisprudence before it said that. That too is worth remembering. But saying this has consequences. And one of them, I would suggest, is that it's just not that credible to say that something is so vitally important to democratic society that we have no opinion on the topic. Now, I am sure some of you will object that I'm missing the point, and that the question is not about whether the state is or is not neutral in relation to the idea of religion, but it is how the state is to respond to the fact of religion when undertaking its functions as a state. Now, of course, this immediately begs the question of what the legitimate functions of a state concerning religion actually are, and there are, of course, many views on this. Let's start with some. The ECHR has sometimes described the state as the regulator or organizer, in fact, of religions, which is, of course, palpably untrue. Whilst it is certainly the case that the state has the authority to exercise power over activities of religious believers and religious bodies, this does not actually make it a regulator of religion or an organizer of religion or religious life as such. It can make things easier or harder for religious believers and religious organizations, but it cannot, and indeed doesn't even purport to, regulate or organize their beliefs as such at all. And indeed, the ECHR has made this abundantly clear by stressing that it is not the role of the state to pass judgment on the content of any religion or system of belief. Now, for some, this is what neutrality is all about, not involving oneself in religious matters. And it is worth reminding ourselves that this is where the origins of the idea of neutrality in the jurisprudence of the European Court actually all began. For nearly 50 years, nearly 50 years, the idea of neutrality in relation to matters concerning religion was virtually unknown to the court and the ECHR system. Indeed, it was generally accepted that states need not be neutral as between religions. They most definitely could have views and preferences, and those views and preferences were routinely left unchallenged by the Commission and by the court. However, in the case of Hassan and Chaush and Bulgaria, a little over 20 years ago, the court found itself dealing with a case in which the state had, in effect, become embroiled in a dispute between two factions concerning leadership within the Muslim community by virtue of its decision not to register as Grand Mufti the person chosen by that community, but to recognize a rival instead. Famously, it said that facts demonstrating a failure by the authorities to remain neutral in the exercise of their powers in this domain must lead to the conclusion that the state interfered with the believers' freedom to manifest their religion within the meaning of Article 9 of the Convention. Let me just repeat that. The authorities to remain neutral in the exercise of their powers in this domain. We'll come back to that. It's worth remembering and reminding ourselves that this is the only mention of the word neutrality in that judgment. The Commission, and this was one of the last cases in which the old European Commission on Human Rights produced an Article 31 report, for those of us who can remember those days. The Commission used the word 3 times, concluding that the executive branch of government in Bulgaria failed in its duty to remain neutral when confronted with a division in the religious community and, exceeding its powers, intervened unlawfully in the internal dispute of the Muslim religious community. In other words, it was all about an excess of governmental power in the fulfilling of a function that the law granted to the government in relation to that community. This is a pretty thin basis on which to build a principle of neutrality within the jurisprudence of the European Court of Human Rights. What the Hassan case really says is that the executive must exercise its powers in a neutral manner. This is a remarkably uncontroversial observation and would be equally applicable to the exercise of executive powers in relation to almost anything. In this case, it was a violation of the freedom of religion or belief which provided the context. But in and of itself, it seems to me that it is not saying anything of particular significance about the relationship between religions, and the state. That all comes later, built on what was said. Now, this is not the place for a recitation of the development of the case law, which is very well known to those in this room. It suffices to say that through a series of landmark cases, the court seemed to arrive at a position that it was the duty of the state not only to act neutrally when exercising its powers in respect of religious bodies, but to be neutral and impartial in relation to matters concerning religion. And then one final step further, to be seen to be so. And as with any observational phenomena, neutrality, like beauty, is in the eye of the beholder. If you see something which you think means that the state is endorsing or favouring a particular religion or belief, then to you, it is. Others may see it differently. This raises the question, of course, of whether it's appropriate for a court in the exercise of its jurisdiction relating to the protection of human rights to decide who is right or who is wrong if what is really at issue are competing perceptions rather than matters capable of objective determination. Sometimes they will be, sometimes perhaps they aren't. In a sense, the road crash case, in which the inherent tensions in the developing jurisprudence of the court became evident, was of course the case of Lautsi and Italy. Does the presence of a cross in a classroom mean that the state is not being neutral and impartial in matters of religion or belief? Well, of course it does, unless you think it doesn't. Or is it the other way round? Of course it doesn't, unless you think it does. And therein, ultimately, lies the difference between the chamber and the grand chamber in that case. For the chamber, the cross was a powerful symbol, a state endorsement of Catholicism. For the grand chamber, it was just there, passively, doing nothing other than being there. Now, setting aside metaphysics and the mystery of religion for a moment, it seems fairly obvious to me that it was both. It literally depends on who is looking at it. We in the UK, and I believe in Belgium too, are very aware at this at the moment, with our contentious domestic debates concerning, in particular, the removal of statues of historical figures now associated with slavery, colonialism, empire, etc., and so on. Taking something away is at least as much of a symbol or a symbolic act as leaving something alone. In my university city of Bristol, there is now a plinth without a statue. That statue was torn down by protesters a little over a year ago, and a jury has since refused to convict those who admitted to having violently torn it down and throwing it into the waters of the dock, and to convict them for criminal damage, which everyone accepted that it was. There's no question that it wasn't, but the jury decided not to convict them. This is not as uncommon as it sounds, but it was a pretty stark example. The statue was of someone who was a great philanthropist in Bristol. Much of the city has his name on it, to schools, to streets, to concert halls, or it did. For he was deeply implicated in the funding of the slave trade 100 years before his statue was put up. There is now an empty plinth where there was once a statue. And the empty plinth is a very powerful statement, as would a wall from which a cross had been removed. There's not a lot of space for neutrality here. Following Lautsi, we have moved on, I think, from the general idea that neutrality and impartiality involves cleansing the public space of the trappings of religion, as has sometimes been called for, on the grounds that those trappings might cause offence. And I think rightly so. After all, there is no right to be insulated from things which cause offence. You cannot have a plinth on which there both is and is not a statue. You have to make a choice as to which it is to be. Now, perhaps what neutrality means here is stepping back from the preconceptions that surround such debates to create that space for a neutrally informed debate. It can be a tool to facilitate public discourse on contentious questions within the democratic space, but without necessarily describing or dictating the outcomes of that debate. I have recently, in writing elsewhere, explored the relationship between neutrality and choice. Reduced to its basics, the European Court of Human Rights, like all international human rights law, seeks, among other things, to hold in tension two fundamental pressures, that of the universal and the local. There are others, but that is one of them. How does one hold firm to the universal values of human rights protection, whilst at the same time respecting the social norms and practices which characterize a particular society? Now, for some, this is a non-question. As the UN Secretary General's Programme of Action a few years put it, it's human rights first, as if. But that's sort of the point, isn't it? Human rights are enjoyed in a context, and an application which is shorn of context is quite likely to result in poor application, or in some cases, no application at all. Rights are not enjoyed in a vacuum, and local matters. As an international lawyer, that of course is where sovereignty kicks in. Like it or not, and some like it more than others, our local is bounded by the bands of statehood. Whilst we share a common humanity and human dignity, we do not all share a common polity. Our experience of rights and of rights protection is shaped by the collective judgments of our political communities. An approach to rights which pays no heed to the political community of which we form a part is likely to be an approach which is going to fail. I hasten to add that I absolutely do not mean that the individual is to submit themselves to the whims and the impositions of the political majority or the politically dominant. The entire point of human rights law is to ensure that that does not occur. My point is that human rights protections and the enjoyment of human rights needs to be respectful of the collective decisions properly taken when seeking to ensure the protection of the rights and freedoms of individuals. This used to be the territory, some would suggest, of the margin of appreciation, and now perhaps of subsidiarity. Neither, however, removes the obligation on the state to protect the rights of those subject to its jurisdiction, or to protect them from, or protect the state from scrutiny as regarding the manner in which it's done. But in the language of this conference, the outcome of that may very well affect what that protection looks like in a practical sense. It is not going to look the same everywhere. And there is no magic here. As we know, those states which espouse secularism are more easily able to justify limitations on religious apparel in the workplace than those which do not. Now, personally, I have always found this a difficult area. I have never been able to understand why an employee wearing something means that the employer endorses what others think it may betoken. If I wear a jacket with a designer label or logo, I don't think this comes into it, but if I was wearing it that way round, there's a label inside. Does that mean that I'm endorsing the manufacturer? But that's just me. I don't get it. But I have to respect that other people do get it, even if I do not. If what I am wearing may legitimately give rise to fears or concerns in others, then that is a very different matter. But to return to the point I made earlier, if the state has an obligation to respect the freedom of religion or belief, I don't quite see how this is compatible with an a priori assumption that the wearing of something which identifies you as having a particular belief pattern has such an effect. At the very least, it needs to be shown that it has. It is not, in my view, to be assumed. But the central point is that the state has a choice. It does not have to be neutral on this. It can choose a more or less secularized state environment, and this has consequences for the exercise of rights. And provided that choice of environment is the product of an exercise of public reason, and that is a big if, then it is reasonable that it should provide the context in which the exercise of the freedom of religion or belief is to be examined. Most schools, an issue we are going to be spending much time looking today. Most schools in some European countries are church or faith schools in one way or another. In other European countries, none are permitted within the public education system, or I think, indeed at all. Both approaches apparently are both justifiable and unjustifiable. But what is clear is neither is neutral. I can understand that there might be a bit of an air of unease about where all this is going and how long it's taking. But hence my concern that this might be an off-keynote address, but I really don't think it is. I'm not arguing in favour of the hands-off approach famously adopted by one of the dissenting judgments in that very first court decision, in which he questioned the legitimacy of the estate involving itself in matters concerning freedom of religion at all, as if it were off limits. It most certainly is not, nor should it be. By the same token, I'm not arguing for the equally problematic approach taken by another dissenter in that same famous case, calling for the state to stand in solidarity with the church. It is definitely not the role of the state to proselytize. But in my view, neutrality eschews such extremes, but it does not eschew preference, provided this does not stand in the way of the exercise of religious freedoms of others. As I've indicated, systems which are secular, laic, separatist, etc., are understood to be compatible with the idea of neutrality. Why shouldn't they be? It surely follows that other systems which do not accept that approach, presumably that recognize a degree of connection between church, religion, and state, must likewise somehow be compatible. It's difficult to see how neutrality can demand otherwise without surrendering its claim to neutrality. The essence of neutrality, it seems to me, does not lie in the nature of the relationship, but in the exercise of the right. If the state, whatever its pattern of religion-state relations, fails in the exercise of its functions to be neutral, as between different religions, then there is a breach of the obligation, its obligation of neutrality. This, in essence, is what the Hasselt case was all about, the starting point of the debates and discussions. On the facts of that case, it is easy to understand why the outcome was couched in the language of neutrality, but perhaps it might better have been viewed as a question of discrimination in the exercise of executive authority. Couching it in the language of neutrality has related in many problems and controversies, which of course many in this room have analysed at depth. But it could be that the state is not, despite what the court has said, required to be neutral and impartial as between religions in the framing of its laws. It has to act in a neutral and impartial way when implementing the framework which it has put in place. But that's rather different. Now, when it comes to the content of that legal framework, the framework itself rather than the application, in a sense, it's not obvious to me that neutrality is the best descriptor of what is to be strived for either. What matters is whether the law breaches the freedom of religion and belief, understood in terms of the exercise of that right, and its content and conduct therefore become two different questions. But let's be clear, it sort of, to me, beggars belief to suggest that a state is obliged not to have a view concerning certain forms of belief and to reflect that view in its approach to them. This may shock some, but I do not know why, since it seems to me to be fairly obviously the case, and has been throughout the jurisprudence of the court. Let us take two of the more recent decisions considered by the ECHR, and I chose them, it's true, almost by random. The ancient Baltic Religious Association in Lithuania case concerned the refusal to register the applicant association of pagan believers. The court found this to be in breach of the convention. But my point is that the law under which the registration was sought, like so many other in Europe. There's different criteria for recognition and registration. The legitimacy of this difference of approach between different communities of believers to registration was not challenged or questioned. What seems to the case had turned upon was that those responsible for the decision, and usually in this case parliamentarians, whether they had acted fairly and in accordance with sufficiently well-established criteria when making the assessment, or whether they had been improperly influenced by prejudice, bias, or worse. And the court concluded the members of the parliament who voted against granting state recognition did not remain neutral and impartial in exercising their regulatory powers. Back to the words from Hasselt. In other words, it was the application of the process rather than the underlying principle that was the problem. This simply reflects very many other cases which have upheld, expressly or impliedly, the legitimacy of registration frameworks, which on, frankly, any objective analysis are not neutral as regards religions, since they make it far more onerous for some to achieve a legal status and the rights and opportunities that flow from that than others. Now, this could only be justifiable if the law permitting this was not itself considered to violate the freedom of religion and belief of the followers of such religions and beliefs. And we have seen cases in which some have, but others apparently haven't. And it's clear enough that this is not necessarily the case. Some laws will be inapplicable or inappropriate and wrongful for this reason if the effect of them is to prevent the effective exercise of the freedom of religion and belief. But this is not really a decision made on the basis of their not being neutral, even if the outcome can be described in that way. And similarly, another recent case, I'll probably pronounce this wrong, De Wild or Wild and Netherlands, timely reminder of what we already knew, but I think don't often always admit, which is that states once again are entitled to determine or able to determine that some forms of religious belief, like some other forms of belief, are just not worthy of respect in a democratic society, and so do not have to be respected from a rights perspective. In this case, what was it? Pastafarianism. Now, I know that the general view is that this is not a religion, but a parody of religion. But if some people mistake the parody for the real thing, or find spiritual meaning in the parody, then who are we to deny them? Well, we are entitled to make such judgments, it seems. And I hardly need to point out that this is not really being neutral. It is the state taking a view about legitimacy, integrity, and worth of a purported belief system and acting accordingly. Rightly, this has been subject to challenge and scrutiny, but the view of the state, in this case, prevailed. So, pardon the expression, Pastafarianism is cooked, at least in the Netherlands. Of course, others can take different views elsewhere, just as they have many other religious groups across history and today. And that's not really very neutral either. It may be that we would do better to think less about the word and more about the meaning. What do we mean, it seems to me? What we mean, it seems to me, is that states are entitled to make judgments about the ordering of religious life in one sense, not a regulatory sense, but in an organizational way within their jurisdiction. These judgments are entitled to take account of a whole range of factors and do not necessarily have to be neutral in the sense of impartial. States can, because they do, have preferences. But the manner in which these preferences are expressed and practice under them must not trench on the ability of others to follow their own religions or beliefs in accordance with their constitutional and convention rights. Difference may be justifiable, but discrimination in the enjoyment of the right is not. Likewise, when implementing such a framework which meets these criteria, the state must ensure it is done fairly, without discrimination, let us say neutrally. This, it seems to me, is what the ECHR requires, and it is a lot. But it does leave much to the discursive space within the state to work out what that means in practice for that state, for that community. And that is, it seems to me, what today is all about. It's not about injecting neutrality into a protective system. It is about exploring the landscape of the protection of the freedom of religion and belief in a neutral way, in particular contexts. And this is a very different, but I believe a far more positive, productive, and possible approach. Neutrality is central to the engagement of the state with religion, religions, and belief. But it is a tool, not an outcome, a means, not an end. Otherwise, it becomes at best a means of avoiding, and at worst, the rejection of one's responsibility to respect, protect, and fulfill the freedom of religion and belief, which itself is a convention right and the vital asset of democratic society. Thank you.
Thank you, Malcolm, for that fascinating opening address. And contrary to what you had promised us, you did actually engage with the question in the end, for which I'm very grateful, but did not offer us a final conclusion. Otherwise, we could all go home. There's still issues to discuss. And I do believe that a lot of this debate today is going to revolve around this idea of neutrality, as some have called it the derivative principle, others a means to an end, a tool. And then the question is, a tool to which end, and how can that tool be used, and when can it be used? And with having said that, I would like to invite the first session panelists to join us on the stage. We have Professors Myriam Hunter-Henin and Professor Roland Pierik, myself, and Professor Marilyn Kiviorg as a discussant.
Yeah, let us start immediately. We have a quite prominent panel of experts, quite impressive indeed. And thanks again, preparing that well professionally, your introductions and your keynote. So we hope to have the full text later on. We will deal with that in the publication of this conference. It's quite interesting indeed how there is an evolution in terms and in notions. On neutrality and in several systems throughout Europe, they have the first a negative interpretation of neutrality and then a positive neutrality. That means that teachers, for instance, in education are allowed or even invited to express their ideas, taking into account the age of the learners. And then, of course, secular systems where we will refine that secularism, that idea, but also pluralism. And the last stage is then active pluralism, what makes some systems a difference indeed. And then the very last stage is reasonable accommodation as a kind of articulation of equality and non-discrimination. There are several PhD theses on reasonable accommodation in education system last 3 years. So we have to debate about the common constitutional principles throughout Europe. Neutrality of public schools, state schools is one of them, but also the freedom of education. So supporting, promoting, subsidizing initiatives coming from civic society. Mostly throughout Europe, they are religious, denominational, but not all of them. So this variety of topics will be at the core of the next lectures. Yes, please. You have, can we move immediately to your...
Yes, sure. Thank you very much.
Roland, we read about your impressive biography. Thanks again, Stijn, to add the biographies into the files, so we can move immediately to your lecture. Yes,
thank you. Thank you, Professor Smet and de Groof, for releasing me from my very small study the last 2 years, in which I've been talking into the screen. And while driving to Hasselt yesterday evening in the sun, I was very happy to just meet people again and to see you all again, and to discuss state neutrality. And I might come up with a very different argument than was given in the introduction lecture, but that's what academia is all about. My paper is more a detailed question: how much room the constitutional principle of state neutrality, which already has been discussed, leave to states to publicly endorse specific historically important symbols. And of course, the most important example here, and you all know this example, is the Lautsy case, which involved the mandatory display of crucifixes in public schools. That latter is important, in public schools. And so in this sense, this discussion is not about the curriculum, about the very clear things that has been taught in school, but about the either active or passive symbols in the room. So this paper is a very small and quite technical element of a larger project. I think I lost. And it is a very first part of the paper I want to write for this special issue. First, I'm gonna discuss the role of Christianity and the role and its relation to state neutrality. Then I engage with the main case I want to discuss, the Lautsy case, and explain that the court ultimately used a wide margin of appreciation in that case. I disagree with that wide margin of appreciation, and to explain why I disagree with why that is used there, I'll delve into discussion of the narrow and the wide margin. Yes. Thank you. So I think it is very important, and Professor Evans already referred to that earlier, that it is important to realize that in the European states, Christianity and the state has for a long time in history have been simply indistinguishable. And that implies that in the nation building and state building of European states, all European states, Christianity is very much imbued in those states, whether we like it or not. And nowadays, in the discussion of secularization and state neutrality, these states had to go through a process of a gestalt switch from being a Christian nation to a neutral nation. Nowadays, they must take a neutral stance towards religion and ideas of the good, including the religion, Christianity, that for a long time was considered, without any argument, as their ultimate normative foundation. But since these states were so Christian for such a long time, Christianity is very much baked into the nation. And if we take this historical context into consideration, this whole idea of neutrality as equidistance towards religion and ideas of the good life is kind of weird. Because one of those ideas of the good life, Christianity, has long been very close to the state, and all the others came later. Secularity, Islam, etc. So there's a kind of an uneven starting playing field already in this discussion. That we should take, it's unavoidable, but we should take it into account in our discussions on the Lautsi case and other cases. So those who defend the ultimate decision by the European Court, those who think that crucifixes are allowed in public schools, if you look at those, that group of people from a more academic point of view, we can call them liberal nationalists. And they think it's right that this historical imprint of Christianity on societies is important. Not because the inherent truth of Christianity or Christian ideals, but because these ideas and these symbols play a sustaining ground for social cohesion in society. As Charles Taylor says, for the people to be sovereign, they need to form an entity and have a personality. And for many people, this state personality, undergrounding sovereignty, it is the history of Christianity. And they see this historical foundation as a source for citizens to feel part of the community, to feel part of something larger. And this is important for them if you want them to pursue the goals like social justice. Why would I pay taxes for someone else's Well, we are a community. We are together in this, and therefore I take my role as a citizen. And these liberal nationalists, David Miller is one of the most important one of them, think that these historical foundations and symbols are very important in funding this shared idea of a shared society. And this idea also can be seen as a foundation of the ultimate choice by the European Court of Human Rights in the Lautsi case. It accepted the mandatory display of crucifixes in public schools in Italy, and it employed a wide margin of appreciation here. So in this presentation, I only want to discuss this choice for a wide margin of appreciation. I don't engage with the arguments whether this crucifix should be allowed or not. That's for the second part of the paper. That's too difficult to present here today. Also, I'm not sure where I want to go there, but I'm quite sure that I disagree with the wide margin of appreciation that has been endorsed by the European Court in this case. So the margin of appreciation is now seen as one of the cornerstones in the convention system. Professor Smet has a very nice paper where he discusses this. And on the one hand, he says, well, it is a cornerstone of the convention. And at the same time, it's unclear what the margin of appreciation is or what it does. And Professor Smet makes the argument, many others make the argument. I have another example here. Stephen Greer, in a recent paper, says that the application of the margin of appreciation by the European Court is uneven and largely unpredictable. For me as a legal philosopher, that's kind of annoying because I want the law to be clear and I want the courts to be predictive. So I feel an unease here in this discussion. So what I want to do is to try to come up with an argument how the margin of appreciation should be applied here by the court, which is, of course, as a legal philosopher, quite an external view on law, how it should be or how the court should apply such a thing. So the margin of appreciation, should it be wide, small, a certain margin of appreciation? You see that a lot, a certain, without giving any idea whether it's wide or small. It is clear that in certain cases, the margin of appreciation of states is very small. When it concerns the absolute convention rights, for example, on the prohibition of torture or slavery, there's no margin of appreciation whatsoever. That's clear. And for very good reasons, of course. We can all understand these reasons. But in the personal freedom rights, 8 to 11, including the freedom of religion, there's no consistent way of employing the margin of appreciation. And I found it very clear in the Grand Chamber case on the loudspeaker case. The margin of appreciation comes there as a deus ex machina, solving all the problems and case closed. And I was really surprised and slightly annoyed by the lack of arguments why the margin of appreciation was given here as a justification for the decision. And to come up with an argument how the margin of appreciation should be understood, I think we should, and this is also done by Professor Smet and others, we should distinguish between positive and negative state obligations. And the margin of appreciation should be different in those two cases. So a positive state obligation is a duty by the state to actively protect convention rights in a conflict between two citizens. There the state has an active role. A negative obligation of the state is to refrain from acting in a way that unjustifiably interferes with convention rights when pursuing certain policies to achieve public goods. So that is a negative state duty, not interfere with fundamental rights when you pursue public goods. And I think that, and I agree with many people who argue that the state should have a very wide margin of appreciation when it comes to balancing conflicting rights of citizens. For example, in the case where the freedom of speech of one citizen violates the freedom of religion of someone else. There, the state should have a wide margin of appreciation. Why? Well, firstly, I think indeed in these cases, the state is better placed to understand the conflict. It is a conflict within their society. It is a conflict within the traditions, within the whole discussion within that society. And I think that in such cases, a national state is better placed to solve the problem. It's better to understand what's going on there, the history, the context, etc., etc. Moreover, if such a conflict can be solved within the states, within the democratic process, and everything that comes with the democratic process, I think there's more legitimacy to the decision than when such a case is solved through an international court, a supranational court. So if it's the outcome of the discussion is the outcome of a public deliberation and public decision making, then it's more legitimate than it would be if an international supranational court comes up with it. A third reason, this is more from the perspective of the European Court, there is no reason in such conflicts between citizens that a state would be unable or unwilling to come up with a good solution. It is a conflict between two groups of citizens or two citizens. The state is not really involved, and the state should be assumed to be able to come up with that good answer. And the final reason, and that is also very important for my later argument, there is no reason for the court to assume that the state abuses her power to direct decision in one way or another. This is merely a discussion between citizens. The state is not a party. There's no reason why the state would use her power in this decision to balance the human rights of these citizens in a direction that it can pursue certain majority goals as a society. But this is also the flip side for the other argument. So the argument here is there's no reason that the state will misuse her power to pursue certain goals, and therefore a wide margin of appreciation is acceptable. In the case of negative state obligations, I think it's different. There we should endorse a very narrow margin of appreciation. Remember, a negative state obligation is to refrain from acting in a way that unjustifiably interferes with convention rights when the state pursues certain collective goals. Well, if these collective goals can be understood as majority goals, then it's not that clear that this state is not an actor in the discussion. To the contrary, usually the state is an actor in the discussion, and then a wide margin of appreciation by the court is much less self-evident. And of course, this is the case of the mandatory crucifixes in Italian schools. That was very much a public goal, but it was also very much a discussion where the state was very heavily involved. And the more state involvement, the less room for a wide margin of appreciation. A narrow margin of appreciation is appropriate when the state is involved in the outcome of a decision. And in such cases, the European Court functions primarily as a heat shield, protecting individuals against possible abuses by the state, possible abuses of power by their government. So in those discussions where the state is a party in the discussion, where the state has something at stake in the discussion, there the court should not accept a wide margin of appreciation. And it's weird to say that in such discussions where the state is an actor, to say that the state is in a better position to balance all the rights and interests than the European Court. No, to the contrary. In those cases, the European Court has a very important counter-majority role to protect the fundamental rights against majority policies by the state. And okay. So let's go back to the liberal national argument, which said that they say that the state, the historical dominant imprint of society and the symbols is very important to generate a kind of a shared idea, a shared personality in the state, and therefore the state is allowed to employ such symbols to further strengthen this shared identity. Well, if the state uses symbols that are quite subjects of discussion, the crucifix, Christian's crucifix, is not seen as neutral by some of the citizens, for example, secularists or Muslims. And if you use such symbols to strengthen solidarity in the state, the symbol in itself turns into a means of exclusion, because it might be seen as bringing people together, those people who endorse the symbol, but if the symbol is not seen by all as uniting, then the symbol can become a means of exclusion. And I think in such cases, since the state is so much involved, and this is very interesting in the Italian case, because many Italians for them, the symbol was so important in the history of nation building, they could not see the non-neutral character of that symbol for others. They were simply unable to see this problem. And in such cases, I think that the European Court should not endorse the wider margin of appreciation, but should really engage and at least not use this wide margin of appreciation and really engage with the discussion in the court itself. So, yeah. So when such cases arrive in Strasbourg, the alarm bells should ring. And the court should understand that here a very narrow margin of appreciation is in place and should engage with the contentful discussion of the case. So my conclusion for the moment is that in a situation of positive state obligations, there are very good democratically enhancing arguments in favor for a wide margin of appreciation when it is the case of a discussion between two citizens where the state is not a party. Then a more democratic way of solving those problems is very good to enhance democracy. But in the case of negative state obligations, there are very many constitutional enhancing arguments why a narrow margin of appreciation is relevant in such cases. And I think, and this goes back to the Lautsi case, I am surprised by the fact that the Grand Chamber in the final decision hit between a margin of appreciation in order not to engage with a contentful discussion of what's going on there. And especially in cases where the state is a party in the discussion, and especially when it comes to such sensitive issues, the European Court should really engage and should not hit itself beyond the wide margin of appreciation. Thank you very much.
Well, it was a powerful, critical presentation by an eminent president of a famous Paul Scholten Center of Jurisprudence. Yes. One of my favorite centers, to be honest. It's very well. You dealt in a very critical, but also very positive way. You also opened the debate later on. So we will have definitely time for debate afterwards, after the three presentations and Marilyn was giving her comments. Myriam Hunter is Prof of UCL, but also dealing with the same principle of intersectionality of disciplines. And you also opted for the more difficult approach, namely multidisciplinarity and comparative law. Wow, we are really curious to hear your presentation. Yes, Myriam.
Thank you. I'm really delighted to be here in Hasselt, and I would like to thank the organizers for choosing such a topical and important subject for the conference. Thanks especially to Stijn Smet for this detailed preparation and correspondence leading up to the conference, and of course to the University of Hasselt for their warm hospitality. I'm also one of those for whom it is the first in-person conference since the first lockdown 2 years ago. So it makes this occasion even more special and welcome. In this paper today, I will focus on religious neutrality as it appears in recent cases decided before Europe's highest courts, namely the European Court of Human Rights and the Court of Justice of the European Union. So what is special about religious neutrality at the level of Europe's courts? I think that at that level, religious neutrality often takes on a meta dimension. As states are expected under the concept of religious neutrality at state level to remain impartial towards their citizens' religious or non-religious views and ways of life, and as it is acknowledged that this duty of state impartiality can be translated through a diversity of constitutional arrangements towards religion, Europe's courts then bind themselves to a duty of ricochet neutrality. So under that duty of neutrality by ricochet, Europe's courts then feel they must remain impartial themselves towards member states' constitutional arrangements in relation to religion. The problem, or at least the change in recent instances, is that this position of restraint towards national traditions has been adopted in cases where states themselves were actually not really abiding by their own constitutional arrangements at all. As a result, the concept of religious neutrality at Europe's courts, before European courts, takes on a very different meaning. It expresses a far more open-ended duty of non-interference into controversial issues surrounding religion, whether they pertain to constitutional arrangements or not. And the justification then changes. It is because those issues are deemed to be best solved at national or even local level. Let's take perhaps two examples. The SAS decision by the European Court of Human Rights of 1st of July 2014, or the Ejbita ruling by the Court of Justice of the European Union of the 14th of March 2017. The SAS case involved a challenge against the French burqa ban, as many of you will know, or more specifically, the French ban on the full covering of the face in the public sphere. The court opened up by a statement underlining the state's role as the neutral and impartial organizer of the exercise of various religions, faiths, and beliefs. But as we know, finally decided that the ban was not in violation of any convention rights. Given, according to the court, that France could enjoy a wide margin of appreciation in relation to this choice of society, I quote, "It was entitled to consider that the covering of the face in the public sphere was necessary to ensure the minimum requirements of life together." Similarly, in the Elżbieta case, deference towards member states in matters of religion was a decisive factor. In that case, an employee working in a private law security company in Belgium had been dismissed for refusing to remove her hijab, which infringed the company neutrality policy. As Advocate General Cocotte had noted in her opinion, and I quote, "In member states where secularism has constitutional status and therefore plays an instrumental role in social cohesion too, the wearing of visible religious symbols may legitimately be subject to stricter restrictions, even in the private sector and generally in public spaces." One important observation to make, I think, first of all, is that both the facts of SAS and Elżbieta fell outside of the confines of the constitutional principle of secularism. If private citizens have been, in the last 10 years, increasingly subjected to restrictions upon their rights to manifest their religion in the public sphere or even the private sector, these legal developments have rarely been based on the concept of laïcité, be it in its Belgian or French version. The special committee set up in France to consider the issue of the full veil prior to the 2010 legislative ban concluded that the concept of laïcité was not relevant to the issue, and indeed, the law did not rely on the notion. So the position of restraint adopted by the courts in SAS and Elżbieta does not rely on the neutrality by ricochet mentioned at the beginning of this presentation. It reflects more a shifting strategy through which substantial decisions in matters of religion are shifted out of the courts and delegated to member states or even in Elżbieta to private actors. So why these shifting strategies? Well, I think it has the advantage of possibly sparing Europe's courts from some of the heat and risks of backlash. But it is clearly not a neutral position. Why is it not neutral? For three main reasons. One, because it does not take a step back from national debates, but has a bearing on them. Two, because it does not take an impartial stance towards competing interests, but favors one set of interests over others. And three, because it reinforces certain assumptions about religion and in particular about Islam. First, in relation to national debates, the deferential attitude adopted by the European Court of Human Rights in SAS portrays a controversial move, albeit voted in a large majority by Parliament, as a settled, long-standing choice of society. Similarly, in Elżbieta, the connection made by secularist countries and neutrality requirements presents as national traditions controversial trends seeking to extend neutrality requirements beyond the sphere of the state. And this presentation, in turn, gives wings to militant trends within the countries concerned and encourages a more radical reshaping of traditional arrangements between state neutrality, state laicity, and religion. Nor, secondly, is this judicial restraint of Europe's courts neutral as regards the underlying competing interests at stake. The margin of appreciation granted to France to define the requirements of life together gives priority to social majority norms over individual rights. The concept of life together potentially operates even a radical change in the protection of human rights. Individual rights would no longer be protected save where an interference pursues a legitimate and necessary aim and is proportionate to that aim. It would be social norms which would be first and foremost protected, save where divergence from those norms isn't too extreme or too visible. Similarly, in Elżbieta, the courts of justice gave priority to one set of interests over the other. The court ruled that the employer's wish to project an image of neutrality towards customers was in principle legitimate under the right to conduct a business protected by Article 16 of the EU Charter of Fundamental Rights. By thus conferring a presumption of legitimacy on company policies, the court seems to implicitly place the private sphere of contractual autonomy as the natural baseline of legal regulation in the workplace. This is not neutral. It could even be said to reflect an although liberal stance, one in which economic liberties should be immune from state interferences. Finally, and that's my third objection, the recent instances of religious neutrality also implicitly rely on a non-neutral conception of religion. Let's move on to the Wabe case, a German case, in which a crèche in Germany adopted a policy prohibiting the wearing by its staff members of conspicuous or large-sized symbols of religious, political, or philosophical affiliation. According to the Advocate General Rentos' opinion, which rightly, in my view, the court did not follow in the end, according to that opinion, the policy of the crèche pursued a legitimate aim, the prohibition of visible signs. And the policy was said to be enforced in an appropriate and strictly necessary manner, as it only applied to employees who were in contact with, hence in view of parents and their children. It's quite interesting to note how the Advocate General presents the visibility of religion as the problem to be solved. And logically, it follows from this starting point that a prohibition targeting only large-scale or conspicuous signs is therefore legitimate. If the emphasis is on visibility of religion, then the larger and more visible the sign, the bigger, logically, under that line of reasoning, the problem. But we then see how neutrality turns into an instrument used to justify the neutralization of religion, or at least visible signs of religion. I do not mean to argue that deference towards member states is never justified, or that the employer's right to conduct a business should never take precedence over religious interests. But what is problematic, in my view, is that because judicial restraint is carried out for the sake of neutrality and is itself therefore presumed to be neutral, its impact will not be discussed, let alone justified. So should Europe's highest courts give up on the concept of religious neutrality? I am tempted to say yes, but I think that religious neutrality could retain some value if it enables that all competing interests are given consideration. In that light, religious neutrality before supranational European courts would no longer trigger the shifting strategies we've described, but on the contrary, prompt fuller justification and a fuller engagement. So rather than hiding the underlying interests at stake and ending up by concealing religion, neutrality construed in that sense would have a revealing effect and underline the positive contribution which religious interests can bring. As for European courts, their role would then be to provide a democratic forum in which equality and liberty interests could be constantly confronted and revisited as new contestations emerge. Thank you for your attention.
Thank you so much, Myriam. Again, a very academic approach, namely critical and creative. Thank you so much. And next speaker is, of course, well known by all of us, Professor Stijn Smet. Although, despite his young age, he published already in a most prominent way in prominent journals and publications. No doubt that you will have a brilliant career in law and in human rights law. Stijn, you have the floor.
Thank you, Jan. I don't think age precludes one from seeking certain venues, and I was happy to have those publications published in those venues. So my talk today is concerned with the interpretation of the neutrality principle by the courts. And throughout the talk, I will make two key points. I'll give them to you up front. The first one is a conceptual point. The second one is a doctrinal one. The conceptual point deals with how neutrality can be used. And it's my understanding that neutrality can be used in one of two key ways, either as a shield to protect freedom of religion and freedom from religion, or as a sword to strike down religious claims. And that first point relates, or I build up on it later for a doctrinal point, and that relates to how courts then respond to arguments by governments that certain limitations on freedom of religion are necessary to uphold the principle of neutrality. So confronted with such arguments from governments, I believe courts can respond in at least three ways. First, through substantive interpretation of the neutrality principle of their own, basically setting forth their conception of neutrality and checking whether or not the government's conception is in line with that. Second, through deference or restraint. We've already heard Myriam refer to that position, as did Roland. So this is the idea that courts do not engage themselves in interpretation of neutrality, but defer to the interpretation given by the government. And third, I believe there is a third way to approach this issue, and that's circumvention of the neutrality argument altogether. Now, before I go into detail on these points, I do want to explain what has led me to them. So I've been thinking about this on and off since at least 2017, and there are three events in Belgium, well, two in Belgium, one at the supranational level, that has led me in my line of thinking. The first occurred in 2017 when a Belgian politician of a major political party floated a proposal in the media to introduce a general ban on the wearing of quote unquote bigger and visible religious symbols in the entire public sphere. But the ban would only apply to religions that represent more than 5% of the population. Coincidentally, that would mean that the ban would apply to Muslims in Belgium, but it would not apply to, for instance, Jews or Sikhs. This proposal was made by a member of the Christian Democrat Party. It was swiftly repudiated by the party itself, but it remains indicative of the overall context in which the neutrality debate has been taking place, at least in Belgium. The second thing that drew my attention was the coalition agreement of the Flemish government for the period of 2019 to 2024. That includes a recurring reference to the need for legislation to ban, in the name of neutrality, the wearing of religious symbols in public schools and for civil servants who are in contact with the public. So here, this is really a moment in which you notice in a coalition agreement that neutrality is being invoked as a sword preemptively to strike down religious freedom. Now, the need for this legislation has since been shelved as a result of government-friendly rulings by the courts in Belgium, and that's something I will return to later. The third development took place at the supranational level. It's the cases that have been mentioned already, case law of the European Court of Human Rights, and to my mind, to a lesser extent, the Court of Justice of the EU, in which you see that supranational courts exercise restraint in key freedom of religion cases by deferring towards the neutrality argument as invoked either by a government or even by a private corporation. So think of the case of Ashbita that was mentioned already, but also, for instance, Ibrahimian and France of the European Court of Human Rights and various other cases. Now, as this broader context developed, my line of thinking has been that to make sense of it, I need to understand how neutrality can operate, and that has led me to the conceptual idea, but I also need to understand why courts engage with the neutrality argument in a certain way, and that has led me to the doctrinal point. So I'll run through these points briefly. The conceptual point is quite simple, frankly, has been made by others as well. Neutrality normally, in normal circumstances, I would believe, functions as a shield, but it can also be used as a sword, and it becomes, in my mind, problematic when it is. So in constitutional law, neutrality, as we all know, generally functions as this shield that ensures equal protection of all religious and non-religious beliefs in order to protect other constitutional ends, such as freedom and equality. And neutrality plays that role by blocking certain state actions, for instance, granting preferential treatment to one religion over all others and over non-religion. And in blocking that kind of state action, it protects non-adherence to this the preferred religion from coercion and discrimination. But crucially, and here comes the rub, this shielding function of neutrality can break down in other circumstances, namely when neutrality itself is invoked as the legitimate aim to justify restrictions on freedom of religion, which is increasingly the case for bans on religious dress in Europe. Now, in those circumstances, what we notice is that neutrality becomes the sword to strike down religious claims. And that led me to think, well, how do courts engage with that? Because we tend to think of courts as upholding the shielding function of neutrality, but how do they engage with claims or cases in which neutrality is used as a sword? And I think they can, as I said, engage with those arguments in one of three ways. They can offer their own substantive interpretation of neutrality, and we'll give the Constitutional Court of Germany as an example here. They can exercise restraint or deference towards the legislator, and I will use the European Court of Human Rights and the Belgian Constitutional Court as my example on that front, or they can circumvent the neutrality argument altogether, and that's perhaps the most novel approach, and I will use the case law of the Belgian Council of State to illuminate that. So this first mode of reasoning is substantive interpretation of neutrality. It's basically a situation in which a court with constitutional jurisdiction, and that occurs in countries like Canada, Germany, and the United States, develops their own understanding of neutrality and puts that forward. And I think the German Constitutional Court is the most interesting example to my mind, favoring this understanding of neutrality as an open neutrality. And I'm going to quote the court here. It is held that the religious and ideological neutrality required of the state is not to be understood as a distancing attitude in the sense of a strict separation of state and church, but as an open and comprehensive one, encouraging freedom of faith equally for all beliefs. And that's in quite stark contrast to how some other courts reason about neutrality. So in German constitutional law, then, open neutrality acts as a shield to safeguard religious freedom by protecting citizens from state action, For instance, state imposition of religious displays. We've heard about Lao Tzu previously. Quite a couple of decades prior to that, in the crucifix case, the German Constitutional Court ruled very differently. It held that the affixing of crosses in classrooms goes beyond the boundary of state neutrality because the cross cannot be divested of its specific reference to the beliefs of Christianity. And so putting up the cross infringes on and violates the religious freedom under Article 4 of the Basic Law. So that's the shielding function. Then the question arises to what when neutrality is invoked against citizens, against their right to wear religious dress in particular. And on this front, the notion of open neutrality also guarantees citizens a right to manifest their religion in many, though not all, public settings. So take teachers in public schools. This is an area in which in Belgium, most teachers are not allowed to wear religious garments, and the Council of State has upheld such bans. But according to the Constitutional Court of Germany, the mere visibility of a teacher's religious affiliation is not as such precluded by the neutrality required of the state. Or in other words, mere reliance on this idea of neutrality in the abstract cannot provide a justification for bans on religious dress in public schools, not even for teachers, in the absence of sufficiently specific threats to either school peace or state neutrality. And that's a quite far-reaching interpretation of neutrality that simply doesn't work in all contexts. So most courts do not favor this kind of substantive interpretation along the lines of the German Constitutional Court. In fact, most courts exercise restraint in this area. And that brings me to the second mode of reasoning, that of restraint and deference. It's clearly the preferred doctrinal approach to neutrality of Europe's highest courts, both the European Court of Human Rights and the Court of Justice of the EU, as we've heard in the previous presentations. Both grant substantial leeway either to states or even to private corporations to determine not only what neutrality means, but also what it requires of individuals. In short, we could say that the European Court of Human Rights in particular has adopted a doctrinal mode that benefits the state. It readily accepts neutrality arguments as a justification for the infringement of religious freedom, with an immediate result that alleged or real victims of rights restrictions at the domestic level are left without hardly any recourse at the supranational level. And various scholars have noted this. And this lack of a supranational remedy becomes all the more problematic when deference and restraint are carried through at the domestic level. And we notice this in Belgium, at least at the level of the Constitutional Court. So in an important 2020 judgment that was related to a ban on religious and philosophical symbols in an institution of higher learning, a college in Brussels, the Belgian Constitutional Court avoided giving its own substantive interpretation of the neutrality principle. Instead, it noted that the concept of neutrality is not understood in a static way by our Belgian constitution, and as a result, it should be inferred that multiple conceptions of neutrality can be in line with the constitutional framework. As a result, the Constitutional Court said it's not its task to give priority to one of these conceptions over others. Instead, it deferred the interpretation of the neutrality principle entirely almost to the lawmaker, but also, and in practice actually immediately, to public schools and their governing bodies. Now, I believe this raises very interesting questions that I touch upon in the paper about who is best placed to interpret the requirements of neutrality in relation to religious diversity in the public sphere. And it's a discussion we can perhaps enter into during the debate. On the one hand, you could make an argument from democracy that legislators are better placed. But you could also submit, as Roland has done, a counter-majoritarian argument that courts are in fact better placed. But I don't have time to get into that at this moment. I want to move on to the third and final doctrinal mode, which is perhaps the one least familiar to people in the room and at home. That's of judicial circumvention of the neutrality argument. And I believe it may well hold the key to solving the problem we are faced with. So circumvention has been adopted as a doctrinal mode by the Belgian Council of State, and there are two building blocks in its approach to neutrality. First, the Council of State has made it clear that neutrality is but a means to an end. We've heard this before. It's a principle or a derivative principle that serves to protect other principles, predominantly equality and non-discrimination. By understanding neutrality as a means to other ends, this allows the Council of State that we see in its rulings to shift its analysis from an abstract interpretation of this general idea of neutrality towards a more evidence-based assessment of the extent to which, for instance, a ban on religious dress contributes to protecting these other constitutional ends that neutrality is supposed to protect. And I'm going to revert here to what is arguably the most important ruling of the Council of State on the subject, a 2014 ruling concerning a ban on religious dress for pupils in public schools. Although I should stress that if the same case would arise today, perhaps the Constitutional Court ruling of 2020 would have precluded the reasoning that is about to unfold. So in this 2014 ruling, the Council noted that there is a difference between teachers and pupils. It noted that insofar as pupils are concerned, there always needs to be an investigation of the way in which neutrality is conceived and implemented, so that the extent to which such conception and implementation of neutrality really fits the objective pursued, the end. And in this case, well, that was the one of protecting public order or the rights and freedoms of others in schools. In other words, again, as we saw also with the German Constitutional Court, the mere invocation of neutrality as such does not suffice to justify a general ban on religious dress, not even when it's neutrally worded. Instead, governments must show that there is a genuine need for a ban to protect other ends, in this case, public order. And in that case, before the Council of State, the government had failed to provide any evidence. The Council noted there was an absence of hard data and concrete testimonies and concluded that not a single piece of evidence had been adduced to support the need for a general ban that would also be imposed in schools in which there was no actual need. In other words, schools in which there was no threat to public order. As a result, the pupils' freedom of religion had been violated. So where does all this leave us? And I'm going to attempt to wrap up in a minute. I've argued that there can be two ways in which neutrality can be used. It can be used as a shield or as a sword. I'm most interested in how courts respond when neutrality is used as a sword by governments against freedom of religion. I've shown that, or believe to have shown, that courts can respond in one of three ways: through substantive interpretation of the neutrality principle, as the German Constitutional Court has done, but recognize that this remains contested. It's often seen as an activist move by courts. And so the German solution might not work in all other settings. At least in some settings, or even in most, judicial deference has provided a solution to courts, a way out. Restraint, as exercised by the European Court of Human Rights and the Court of Justice of the EU, certainly raises fewer charges of judicial activism. At the same time, it becomes problematic when mere invocation of the principle of neutrality by governments, and I do think we can see this in the case law, suffices as such to justify far-reaching intrusions into religious freedom before supranational courts. Not much more is needed than a government to refer to the need for the protection of neutrality for supranational courts to defer. And when domestic courts follow suit, as the Belgian Constitutional Court does, it becomes all the more problematic. Here we are in a setting in which adherents to minority religions risk being left without any recourse at all before the courts, either at the national or at the supranational level. And I think to some extent this third and final doctrinal mode of circumvention of the neutrality argument may well hold the key to overcoming this challenge. Because it allows courts to examine evidence for and against threats to the constitutional ends that neutrality is meant to protect. It thus enables courts to evaluate whether concrete ends, such as public order, are actually in peril, rather than be distracted or remain distracted by the inevitably abstract requirements of neutrality. And I believe courts are better equipped at doing so because it does not require, for instance, philosophizing, and it does not require simple deference. They're well equipped to execute this kind of evidence-based reasoning, for instance, in the shape of a proportionality test under the right to freedom of religion. Now, all of that does not mean that neutrality has all of a sudden become a redundant principle, but it does mean that it should perhaps not play quite as central a role in courts' reasoning in cases on religious diversity as it currently does.
Thank you. Impressive indeed. Thanks so much, Stijn. So thanks also to Myriam Hunter-Henin who accepted to take up the role as a discussant. We know you are a very loyal partner in the European Education Law and Policy Association activities. You're teaching at the University of Tartu and Oxford. Yes, please, Merlin.
Thank you, Jan, very much. I have very big shoes to fill here. Two powerful women have given up to comment on these three wonderful panelists here, Professor Talkens and General Advocate Cocotte. So I feel rather uncomfortable, I have to say, and I got that task yesterday, so by no means my response is not going to be, I mean, very intellectually developed, I would say. And so I'm glad I do not have to stand there, because that would mean that I have something rather important to say. But I'm very comfortable sitting in this corner and commenting piece by piece on what caught my eye in this quick reading. And I will go paper by paper, and I have maybe very, brief, very how would I say that for very brief comments on what caught my eye when speed reading the papers and listening to you now as well. And I will start with Roland then, and I mean, actually that applies to all the papers as well, and as we have actually by now learned that the neutrality is a controversial concept, and even how the European courts have been using this concept, it's not clear to put it in one word what it means, and we have to probe into what it is or isn't, or is it useful, or is it actually have been inhibiting, I would say, protection of freedom of religion or belief as one of the individual or collective rights. But what caught in my eye, perhaps in specifically also in Roland papers, and actually with my apply to Myriam's as well, is that that how much we actually can talk about the neutrality in a general way. That how does it actually mean that there is something we can generalize at all? In my view, all these specific cases can be categorized as like one setting we're talking about education, and the other setting we're talking about using or wearing symbols at the workplace. I'm coming actually from Estonia and Eastern Europe, and in Eastern Europe we have this bulk of case law going to the European Court of Human Rights since the collapse of Soviet Union, which also deals with registration issues. And then there we see how, and Malcolm was pointing out Hasselt case as well from Bulgaria. It's one of those cases as well, where you see that the court is using that as a very much of a thing to a neutrality and a small margin of appreciation in these cases. So that's a kind of a general comment, maybe to the first two papers mostly to think about. And I apologize if you addressed it and I missed it. To Roland, I was thinking that you made an argument in your first part of the your paper thesis that we moved from this sort of like a Christian traditional sort of setting towards sort of more of the requirement of neutrality, which actually means the equidistance. And if I'm thinking about that, and I was putting this argument into the framework of the European Court of Human Rights, and I'm thinking that actually the court have never asked for this complete equidistance, and that's maybe something needs to be thought through here a bit more to exactly through this, repeated say of that, we do not really necessarily say anything about the proper relationship or what exactly, or whatever the court means by that, what exactly needs to be the relationship between the state and church. Let's say that we have established churches, we have states where they are established, or we have strict separation, like in France, and all these systems in one way or the other are acceptable by the court. But of course there have to be some sort of minimum standards. But as we know, we already we do not actually know what exactly these minimum standards exactly are, like Malcolm was saying. Another specific thing I picked up in your paper was this division between positive and negative duties, and how you relate to these. And I was thinking that for me, from the reading, I missed this division between the three kind of categories, like positive duties, sort of to protect and fulfill. And can we actually say that for the division to protect the positive duty, can we actually say that the margin has to be wide, or has been wide? Because I think the margin there is narrow, rather, and more maybe similar to the where in the case where we protect negative duties. Or I don't know whether my argument comes clear here, but I missed this, because if you think about the categories of duties and negative, protect, respect, protect, fulfill, and then protect, I mean, especially in the cases of also from the Eastern Europe, where there have been, a case, for example, against Georgia, where communities physically attacked, and the state was found not to actually fulfill its positive duties to do something. So the margin was rather narrow. Okay, I'm not. I thought I will not have nothing to say, but now I'm actually abusing my time probably. So feel free to cut me off when you need to. But to the second paper, I was also thinking that I was thinking that would you also kind of see what you argue is the sort of like a strategic shift in the court's kind of reasoning over the neutrality? Would you also see it in the context of what these courts are actually about? I think this also plays a role here, because if we think about the European Court of Human Rights, and the European Court of Human Rights was the court for, established exactly for the human rights, entire frame, individual human rights first of all, but then also for collective freedom. But we have that, and also we have to bear in mind it's an international court, and with that come certain restrictions. I think the European Court of Human Rights, if I mean, maybe I'm taking it too far, but had needed to fight for its own survival as well. I mean, margin of appreciation is also the tool for actually, shift somewhere in between of, I'm trying to tell you something here, but okay, I have to also accept your state sovereignty. And also regarding now the latest cases, well, I'm thinking, well, I don't even want to say that. Well, Russia has already previously, in a Russian Supreme Court head, Zorkin has said that, I mean, we're not going to be looking at what the European Court of Human Rights is doing, especially in the very sensitive cases, also concerning religion or for example, homosexual partnerships. So I was thinking that, and in the case of European Court of Justice, I was thinking that maybe also this initial focus of the European Union entirely on something different. I mean, the economic union, and hence the emphasis very much in that court on the on his sort of what I think you use the word contractual freedom of the at the workplace to deal with the symbols in a certain manner. I think I'm over exceeding already. Or I have one comment here. It was a very small one. Well, I had a few more for Myriam, but well, maybe we can. Okay. Let me see. I'm using technology, which is a little bit new for me. Although, okay, where are you? Here. I'm sorry about that. Oh, okay. I will maybe say something later in that case. I will stop here. I'm not going to take time too much of probing around and trying to find the technology.
Thanks so much indeed. Perhaps there is some room for questions from the audience. Sharp, quickly. Yeah. Yes, Ben. Professor Vermeulen. He can speak loudly. We know Ben Vermeulen.
We don't in the room. Those people on the computer can't hear.
Okay.
This one works.
Hola.
I only have a short question for all the speakers, which was very informing for me, but left me confused, nevertheless, at a higher level. One question. I think that the notion of national democracy is also relevant here. And wouldn't you say that the relation between church and state, religion and state, isn't it a question of constitutional identity, which fundamentally has to be determined by the national legislation? So it's not the main reason why the courts remain at a distance, that they feel, well, that is the core business of national sovereignty. And only in very special cases that are very intrusive of individual freedoms, I may intrude in that sphere. So the role of national democracies as to supranational courts.
Excellent. Thanks, Ben. Yes, another one? Second question or remark, or not for the time being? Well, Professor Evans? No? Welcome.
Lots of comments.
Go ahead.
Thank you. Lots of thoughts and comments, but I wanted to give other people the chance, because I've been able to have the privilege of having the floor for so long this morning. But there is one particular one I would perhaps to Roland, really. I listened with great interest to your arguments about the positive negative division. I suppose the only question to me is, how far can you actually take that? Because, to me, if state A has got a positive obligation, for example, to settle a dispute between two in a new issue, let us say whether or not there should be a cross in a church, yes, in a school, and people are arguing about this, and it looks at it, it considers it and says, do you know what? We think it's okay. Yes. And so we say, it's okay. Yes. We have settled that dispute between two people. We have fulfilled the positive obligation that was in contention between the parties. And then one of them just comes along and says, that's the state imposing an outcome on me. It's a negative obligation not to violate my right. So it's a negative obligation. Mm-hmm. Do you not just run the risk of saying, well, the state has got a wide margin of appreciation to get it right, but if it gets it wrong, as far as we're concerned, we'll give it a narrow margin of appreciation and tell it what to do at the end of the day? In other words, to use the expression, you're giving the state rope to hang itself with, to use that expression. If it gets it right, fine. If it doesn't, tough.
Top. Okay, last question from the audience, if there is. Colleague, No? Then a quick reply from the panel.
Shall I start?
Yeah, yes, please.
I think both questions are very important to my paper because it is, I like to, as a philosopher, I like to make boundaries, and you legal scholars always show that my boundaries don't work. And that's my problem, of course, because I discuss it with legal scholars. But one thing I would like to reply to you, and I think that I think the court can only determine whether a state overstepped its boundaries by taking the case. And what happened in Lautsi, in the Grand Chamber, is that they, maybe for good political reasons, for reasons you already mentioned, because the court was under pressure by Italy and other states. But in the end of the day, by giving in right away into the wide margin of appreciation, it didn't even engage with the arguments. And so my argument is here, it should not hide beyond the wide margin of appreciation. It could still come to the same conclusion that the crucifixes are justified, but then it should give arguments, and it didn't give any arguments. That's my problem there. And to Ben, so here's this joke where one says, I take the unimportant decisions, and my wife takes the important decisions. And then someone said, well, who determines what is important and what's not important? I determine what is important. And that is, of course, the discussion we have in this here. In the end of the day, what's the threshold where the European Court says, well, here they overstepped? And I think that is a totally complicated question to answer.
Thank you, Roland. Myriam?
Thank you, and it is at the right level. I think the question of democracy applies to my presentation a bit more, so I will answer this question first. I agree that, especially from supranational courts, it is legitimate for the courts to want to be sensitive to constitutional traditions and deferential towards constitutional identity features. But what I tried to show is that actually what happens is that deference is expressed when those constitutional features are not involved at all. Ashvita came as a surprise in many secularist countries as well. It went far beyond, for example, the newly passed law, and was not seen as involving laicite, at least from lawyers, because it occurred in the private sector altogether. So actually, there is an inflationist trend sort of pushing constitutional law tradition beyond this remit. And there's also a question about how this deference should be carried out. And here maybe a comparison between Ashvita and Ibrahimian, the European Court decision, might be useful. In Ibrahimian, the European Court of Human Rights deferred to the constitutional principle of laicite in France, and hold that as a result of this principle, the dismissal of a public agent working in a public hospital in France because she refused to remove her, it was just a headband or coif, was justified. I think the difference between Ibrahimian and Ashvita is that the principle of laicite was actually applicable under French law, whereas it wasn't in Ashvita. Two, the European Court of Human Rights left room for future dialogue. So it imposed two limits: the fact that it was a public agent, which actually is more restrictive than French law is, and the fact that it occurred in the sector of a public hospital. So this leaves room for further discussions in future cases where restrictions might be applied to private agents or beyond the educational or hospital sector. Whereas in Schwiete, the debate dialogue was sealed, the employer was given the upper hand from the start.
Takes me up, Stijn.
Yeah, I also maybe want to come in on the democracy question. Both of your papers actually made me think of that as well, because you both suggested that, well, Myriam, you suggested that pluralism could be democracy enhancing, and it made me wonder how it relates to the court's age of subsidiarity, which it also sees as democracy enhancing. And a similar thought occurred in your paper, Roland, to me. But colleague Vermeulen, I want to take you up also on the reference to democracy and constitutional identity. I think we should also be careful, or at least aware of the differences within Europe on this front as well, because there are nations in the east of Europe that currently emphasize their Christian heritage and their national identity as a way of indicating that perhaps they're not able to comply with all human rights at present. So the further emphasis on constitutional identity and democracy might be beneficial in the case of Western European countries, but it could be very problematic in the case of CEE countries. And then the question is, can the court really distinguish and reserve the wide margin for some countries and not for others on these issues? So I realize where you're coming from by putting it on the table, but there are certain risks involved as well. And then maybe it's now 11:35. So I think in the interest of time and with apologies, we're now 20 minutes over time. We might have to conclude this panel here. I suggest we reconvene a little bit earlier to catch up on time a bit. So at 11:55, and then we'll really catch up again over lunch, because we had foreseen that, but not exactly to this extent. So we'll reconvene at 11:55. The coffee is in the room where you know to find it. Yeah. Thank you.
Thank you.
Interesting presentation.
Ja, ik denk als organisator zit je soms meer met de praktische kant van zaken bezig. Maar ik probeer mijn best.
Dat is wel leuk, ja.
Ja, ik ga even snel. Hier zijn echt iemand die zit in het volgende panel en die dus een PowerPoint.
Ah ja.